Hello, I'm carrying on with tort, looking at trespass to the person and various defences. We'll look now at the defence of necessity. So this one is not interpreted broadly. Necessarily, the court has to be very cautious about saying that's not trespass to the person because it really was necessary to touch the person. So if the defendant was doing something to the claimant to avoid greater harm befalling the claimant than was caused by that trespass to the person, then that'll be a defence, or is to prevent harm to the public, or the defendant was preventing himself being harmed, then the defence, then that defence will lie. So this means that sometimes the paramedics can touch people against their wish in an emergency situation. If they found somebody unconscious or something heavily bleeding or things like that, if the person doesn't know what he or she is saying in shock. And the courts can authorise some medical treatments, even very invasive ones, because some people have no mental capacity, don't know what's going on, or have no idea what's in their own best interests. They might be in a coma. For instance, they might be seriously mentally ill, very mentally subnormal, things like that. So the principle here was upheld in the House of Lords in a case called Ray F. 1990. The treatment must be one that would be recommended by a respectable body of doctors. Bolam against Freon Hospital 1957 was such a case where the principle was initially laid down. So let's look at self-defense now. So this is a justificatory argument which can be held valid if the force was used was reasonable and proportionate, bearing in mind the level of danger. Cockcroft and Smith 1707 is a case about that. So Cockcroft had put his forefinger towards Smith's eyes during a fight. Smith bit off Cockcroft's finger during the fight, and was this a proper self-defense in the situation? So it's found that we can only reasonably use force in self-defense, but Smith could not justify biting off somebody's finger. So Lord Justice Holt said this: hitting a man a little blow with a little stick on the shoulder is not a reason for him to draw a sword and cut and hew the other. So it can't be very disproportionate. So it's up to the defendant to demonstrate that the level of force used was permissible self-defense. And obviously this is decided on the balance of probabilities, because we're talking about a civil matter here. And the defendant needs to prove that this defense was legitimate. Remember, we're talking civil law, not criminal law. In Ashley against Chief Constable of Sussex Police 2008, Mr. Ashley was shot dead by the police during an armed raid at his home in the wee hours of the morning. The police said there was negligence, and they said they were responsible for the damage which followed the raid. But they said they had no liability for battery because the officer in the incidents who shot someone did so in self-defense. So with the issue that the court had to take into account was whether the defendant, who mistakenly but honestly believed he had to defend himself against an imminent risk, could use this self-defense argument successfully, because he had an honestly held belief, but it was erroneous. So the argument by the other side is it could not be reasonable, ipso facto, by it being bogus. Though he held it sincerely, the belief was mistaken. But it was found that, unlike the position in criminal law, here the belief must have been a reasonable one in the opinion of the court. So the defence is open to anybody who goes to assist somebody else under attack. In Beachy against Ministry of Defence 2004, this self-defence argument failed. Soldiers who were participating in the United Nations peacekeeping mission in Kosovo, who were not being threatened, shot the claimants, and there was no reasonable reason to believe that they were in danger, so they were liable. How about deliberately inflicting psychological harm? So this is a tort here. Wilkinson and Doughton is in a very important case. It's an 1897 case. So the sort of behaviour that can be battery includes situations where there's no physical contact whatsoever. And the liability can come about through words which are intended to cause some harm. It might be severe stress, it might be psychiatric damage. In Wilkinson, the defendant, who as a prank told a plaintiff that her husband had been seriously injured in an accident. And because of this information, the plaintiff then had a nervous breakdown. So it was held in this case that, first of all, there's no recovery and negligence for psychiatric harm, and specific requirements for assault had to be the application of physical force, and that wasn't here in this case. Therefore, the plaintiff couldn't claim trespass to the person. But the court said they distinguished particular facts from trespass to the person and found that the defendant was liable for wrongful interference in what he had said. He lied. He knowingly told this mistruth to cause great anguish to the woman. So the behaviour had not been negligent but was intended to cause harm. So liability came about because the principle laid down in Wilkinson and Downton, if an act is carried out intended to cause physical harm or psychiatric damage and does indeed cause such damage, then a person is liable. So defendants' words or behaviour must be of their own free will, and there must be some uncertainty as to the level of harm that he intended. In Wainwright against Home Office 2003, the House of Lords said that recklessness as to the consequences are enough, but then that was rejected by the Supreme Court in Rhodes against OPO 2015. That was a case about trying to stop the publication of a memoir on the basis that its contents were going to be very upsetting to the author's son. Wilkinson is held to be inapplicable because it couldn't be taken from this that the defendant wished to cause grave mental or emotional distress to the plaintiff. So how about the protection from Harassment Act 1997? This was passed partly because there was a growing understanding of the heavy impact that harassment has on people, following people constantly, or the press intruding into people's lives. So this was passed providing both civil and criminal penalties. And Section 1.1 says a person must not pursue a course of conduct A, which amounts to harassment of another, B, which he knows or ought to know amounts to harassment of another. Close quotation. So course of conduct, it has to be at least 2 occasions. Often 2 would not be held to be sufficient. It might be 20. So harassment includes the following, but is not restricted to the following: alarming the person by causing the person distress. Section 3 says a person can bring civil proceedings for damages and an injunction to cease and desist from such conduct. There's also trespass to land. So this is preventing interference with people's landed property. Going on to land is without the person's say-so is a civil wrong. It's usually not a crime, apart from specially designated areas like royal palaces, military bases. As with trespass of the person, the unlawful interference of land must be direct and must be deliberate, and it's actionable per se, as in you can immediately take action even if no damage results. Nominal damages will be awarded though unless there's proof of actual damage to the land. If your intention is to enter the land, that has to be essential for liability. Being there unintentionally is different. An intention for trespass is not required. So a guest who walks up a drive to the front door of the house believing it's the home of this family, but actually it's not, it's the other one, he's not a trespasser because he had no intention to trespass. Okay, so there's Bastley and Clarkson, 1681. A defendant was mowing the land that he owed, and he went over the boundary into somebody else's field by accident and mowed somebody else's land thinking it was his land. The defendant pleaded mistake to the claimant trespass failed because his act of cutting the grass was deliberate, even though he was mistaken about whose land it was on. He wasn't clear what the boundary was. So you have to bear in mind that trespass to land is to prevent direct interference to land, and these can be, no matter who they're carried out by, walking to somebody's house, walking on their garden or something, leaning against the fence or sitting on the wall. Gregory and Piper, 1829, a lot of rubbish on the defendant's land accidentally collapsed and fell against somebody's wall. The court said that this was probably a natural consequence of rubbish collection, but it was actionable trespass. Indirect interference with the use or enjoyment of land, such as odours, smoke, steam, and noise, are the tort of nuisance. So the noise abatement team can be on you. So land includes the surface and anything attached to the soil, like houses, walls, standing crops, anything beneath the soil, trees, and the airspace, up to a reasonable height. It doesn't go hundreds and hundreds of metres up. So in Kelson against Imperial Tobacco Company, 1957, an advertising that went a few inches over somebody else's land was trespass. And Woollerton and Wilson against Richard Costain, 1970, a builder was found liable in trespass because of a crane that overhung somebody's land. But invasions of airspace are actionable. So the landowner's rights in airspace above are not unlimited, because otherwise planes could fly above your land. Bernstein against Skyviews in 1971, intruding in someone's airspace was what happened. Bernstein took out an action, trespass, for taking aerial photographs from hundreds of meters above his land. The court found that Bernstein had no reasonable use for the airspace at this height, and so that was held to be no trespass. So who can bring an action in tort about trespass? Tort is there to protect a person's possession of land. So only the person who has exclusive possession can sue and trespass. So sublessees cannot, lessees cannot. A landlord of a leased premises does not have exclusive possession, nor indeed does a lodger or guest, that they are incapable of bringing an action. They've got no locus standi. Remedies for trespass to land are usually damages, sometimes an injunction, sometimes a self-help in order for possession of the land, saying that the plaintiff has title to the land. Bye.